Hello, welcome back to the Mission Mediation podcast. We are live once again. Thank you for joining us wherever you are. Good morning, good afternoon, good evening. To all those of you joining from Australia and New Zealand, thank you so much for this. Oops, seems to be a bit of an echo there. Let me see if I can fix that from my end. It's gone away now. All right. Once again, thank you so much for joining us live. This is the Mission Mediation podcast. I'm Jonathan. I'm the mediator and founder at the Pact. I'm joined by my partner at the Pact, Nishant Laroya. We've been on this journey for the last 10 years now, promoting mediation in India, teaching mediation in India, practicing mediation in India. And this has been a fantastic journey for us because we've had a chance to meet with some exceptional individuals who are making it happen in their own space. We've already had 2 episodes on the Mission Mediation podcast. And on those 2 episodes, we focused on the role of the mediator and we tried to understand what does it really take to sustain a profession as a mediator. But today's focus is on the role of a lawyer. Once again, a provocative question there. Are lawyers relevant in mediation? We've been harping about this for quite some time now, over the last few years. We created an academy called the Global Academy for Advocacy and Dispute Resolution way back in 2019. Had so many batches of lawyers who have trained to be mediation advocates with us. We've had the great privilege of collaborating with Jeff and Tad at Maxwell Mediators when they came down last year, and we had a few cohorts of mediation advocates trained and certified in Bangalore and Delhi. And today, of course, we are joined by Jeff and Ekta on this fantastic conversation on the role of the lawyer in mediation. I can't wait to dive deep into these conversations. We're going to have some case studies. We're going to break that down. And we're going to then get into some more, I would say, academic stuff as well. And we got all but 1 hour to do all this. But for those of you who are not following us yet on YouTube, you can just click on the subscribe button. Go search for the Mission Mediation podcast by the Pact. Click on the subscribe button. That way, you don't have to miss any of the episodes coming your way. And if you're on LinkedIn, please follow us as well. And you get more updates in the space of mediation in India. We're always putting up updates about what's happening in the space. There's a lot of activity, by the way, in terms of something that's very relevant to mediation lawyers in India. There's so much happening in the Delhi High Court over the last couple of weeks. A lot of cases that have come up that have really brought into prominence mediation and the practice of mediation. And we're going to dive into all that as well. But I want to quickly introduce you to Jeff and Ekta. Of course, it will take me a whole hour to introduce the two of them to you. So I'm going to keep it very brief. Jeff Sharp joining us all the way from New Zealand today, but he's based all over, actually. He's based in London, he's based in Singapore, he's based in New Zealand. He's a seasoned international mediator with mediation chambers, as I said, in Singapore, London, and in New Zealand. He's an online specialist, having mediated cross-border disputes online, including construction, aviation, maritime, and also in the pharmaceutical industry. He's the founder of Maxwell Mediators in Singapore and a door tenant at the Brick Court Chambers in London. And of course, he's a Who's Who Legal Global Elite Thought Leader for 2024. So, Jeff, thank you so much for joining us on this probably a very exhausting Saturday evening already for you there.
Thanks, Jonathan. Very generous introduction. And hello to everybody. Thanks for joining us.
Thank you, Jeff. Also, big hello to Ekta Bal, who's joining us all the way from, is it Hyderabad, Ekta, today?
Absolutely.
It's Hyderabad today. Ekta is once again a traveling mediator, traveling a lawyer, and she's always around, always makes herself available for these fantastic conversations we have. She's a partner at Samvad Partners, an empaneled mediator with the Center for Mediation and Conciliation, a member of the SIMC Specialist Mediator Panel, an accredited mediator with CIMI, and of course, an accredited mediation counsel with us at Pact and Garda. We are really excited about this one. I know Nishant and I have been talking about this for the last whole week now because Ekta and Jeff make the best conversations. So I'm not going to waste any more time. I want to dive straight into it. Before I hand it over to Nishant to get into the case studies, I want to put out that provocative question to both of you. Are lawyers actually relevant in mediation? Ekta?
Well, I'm a lawyer, so I'll always say yes. But
Right.
even I wear 2 hats. So I wear a hat as a lawyer and a mediator, and I've
Okay.
seen disputes where you have lawyers, and having a lawyer in mediation is not just having a lawyer; it's a lawyer who's ready for mediation, who understands mediation. I think they can add significant value. So it's not that you don't have mediation without lawyers present, but invariably, when you look at the final settlement, lawyers are trained to think, very logically. They're trained to think in terms of the law. They train to think in terms of what will be the outcome of a settlement agreement. In terms of if you're looking at playing it out over a period of time, and eventually, if you look at in mediation, you want a settlement that is not just a settlement on the table, but a settlement that eventually works. So when
Yeah.
you're looking at, and not all mediation settlements are like, I'll pay you a certain amount of money and let's get over with it.
Mm-hmm.
There are mediated settlement agreements that require performance over a period of time. And how that will play in both the regulatory space, how will that will play in, in terms of doing a reality checking to see, do you have potential pitfalls? I think lawyers are trained to do that, especially if you're looking at me as a transaction lawyer. I look at transactions day in and out. So when I'm on a
Right.
mediation table and I'm working with my clients, um, the BATNA becomes very relevant. And I think as a lawyer who's getting into discussion in terms of trying to get a deal on the table, a settlement on the table, I
Yeah.
think lawyers have particular insights. And having for a client, also having a trusted lawyer on the table with them who can navigate the process, because sometimes there are, offers made which seem very good.
Yeah.
But to have that conversation to say that it seems very good, but is it really good for me? Having
Yeah.
that lawyer on the table whom you could confide in, have conversations with, and figure out, if would it be a good alternative for me, that, I know that what my position would be. I know the case law outcome if I get
Yeah.
into litigation. Is it still worth my while?
That's
Um,
interesting. The whole point of everything that glitters is not gold kind of thing, and having
correct,
a trusted person next to you to kind of make
correct.
that call.
Right. No, and even a conversation like I might have this very strong case for a win, but is
Yeah.
this deal on the table still worth my time, considering I'm assured of a win?
Sure.
Because sometimes
Sure.
it's not just the fact, you're winning in a court of law, but, in especially when you're looking at issues, and you're looking at, what makes sense for me. It's not necessarily just getting the win. When does the win come? What does the win
Right.
cost? Not just in terms of money, in terms of time, emotion, in terms of relationships. There are lots of other factors that the legal system, purely if you look at from a conflict perspective, from an adversarial process, does not factor in into a person's journey. And when I'm talking about a person, I'm talking about not just an individual, but even a corporate, because even
Mhm.
corporates have goals, they have ethos, they have outcomes, they have employees. So there are other factors that do play in. And I think having a lawyer on board who understands mediation and understands the client really helps.
Awesome. Jeff, you have worked with lawyers all across the globe. So the question to you there, are lawyers relevant in mediation?
Well, I think my view on that changes depending on my last mediation and how the lawyers behave. But no, I think absolutely lawyers are relevant. Good or bad, they are stakeholders in the process. So there are a number of stakeholders around the mediation table, the parties, maybe their advisors, their legal advisors, their financial advisors, their supporters. So a number of stakeholders, and lawyers will always insert themselves into a mediation, and good or bad, they're relevant. But I do think probably a more interesting question is, are lawyers essential in mediation? And I think for the large majority of mediations I do, which are in the legal industry, they absolutely are. And if I think about the memorable mediations I have done over the last couple of years, a large reason they are memorable is because the lawyers were good. And we can talk more about,
Yeah.
sophisticated, good advocates later.
Yeah.
But I've seen junior lawyers who know about mediation run rings around senior lawyers who don't know anything about mediation. So the caveat is, yes, they're essential, yes, they're relevant, but only if they know their way around a mediation room.
Absolutely. It could be either a boon or a bane in that room, depending on how skilled and knowledgeable you are about the process. Um,
Yeah.
Once again, this is the Mission Mediation podcast. If you're joining us live, please drop us a hello on YouTube or LinkedIn in the comments section. We are going to dive into some case studies right away now. But yeah, please get your comments coming in. If you have questions for the speakers, put them in as well in the comments section on LinkedIn, and we will take them up. Nishant, over to you.
Thank you so much. And yeah, this is my favorite part of the podcast where we jump into a real life case study, because we all know that mediation is confidential, and a lot of success stories are not out there, but there is still mediation that's happening. So, Ekta, straight away to you, would like to know a brief summary of a case that you'd want to share with us, of course, within the realm of confidentiality. And then would like to break it down in as far as the role of a lawyer is concerned. So if you can give us an interesting or a challenging mediation that you recently were a part of.
So, in fact, finding one case I thought was a thing. So, I'm actually going to look at um, three cases, and the outcome. It's based on how we looked at what we got on the table. One was one was a mediation where there was no counsel on the other side. Um, the other one is that was an employee dispute. It was before the NCLT, so it was actually referred by the NCLT for mediation, and we were counsel for the company. The other is a family dispute where the counsels were actually kept off the table. So counsels were there, but we were off the table. So we had engagement with our respective clients, but if we wanted to do anything, we had to do it through clients. The third one was an IP dispute, which was pre-litigation, and so that way. So, a brief summary. One I'll talk about where there was no counsel in the dispute. We had a very clear mandate from our client that a client was willing to settle. We had a very good. So we engaged with the client earlier to see what were the advantages, what were the disadvantages. Uh, our client on technicality had a great case, but on merits it was a little off. So, but our client was very clear that if there was anything, because it was dealing with an ex-employee, they were very clear that law or no law, we are willing to settle. But they were very clear that we cannot sign up to whatever the client, the other side was demanding. So we had we had engaged in conversations. I think we spent quite a few hours before the mediation. In fact, we were talking of mediation actually even while when the NCLT, when they came into when the petition was filed. Our client we'd always reached out to the other party saying, we're willing to settle, but we cannot give everything that you're asking for. This is our position. We went into mediation also with the same position. Um, the mediator tried to say that, and we'd informed the mediator that we are willing to settle and we are willing to pay, and this is the kind of amount that we're paying. We were very open with the mediator, saying that how we look at what the law says, and if we had gone to conclusion, what we saw both the outcomes, that we won, we didn't win, and we were saying that given all that, we are willing to go up to a certain amount. The other side came with a very positional view. So it was very, very positional. He came on the fact that he was entitled, and and a lot of his content was very emotional, which was understandable because he was talking about his history with the company and what he was entitled to. And he refused to move. He did not have counsel. He did not have counsel who could have reasoned with him or explained to him what we were trying to say. The mediation failed, and we won in the NCLT. And my client was saying that even though it was a win for him, he didn't feel good about it because he had come with the intention to settle, and there was no way he could have given the other gentleman money, without, you know, uh, from his reputation, from his position. He said, I could have just given him a check. It had to be done in a way where I could have closed my accounts because I was dealing for a corporate. And since the other party was just not willing to listen, eventually it was a win. But even then, my client didn't feel good about the win. So that's one example. The second one was where we were counsel off the table. The
If I
demand,
could go to the
yeah,
first
yeah,
example,
yes.
when in such a situation you have a client who's also wanting to mediate, right? How do you work towards the preparation with that client? What's the process that you end up following?
So one is we knew because the matter was already before the NCLT. So from a position perspective, we had already had discussions with them at the time of filing the pleadings. But once it was referred for mediation, uh, see, my client was always, in this case, my client was always willing to settle. But it was about how do you figure out what is the amount you want to offer and when do you want to offer. Um, so we actually sat with our client first and said, okay, fine. We went through with what the legal position was, in terms of if you're looking at PF, if you're looking at gratuity, on the assumption that if the court had held, so while we were arguing that we were not liable to and those didn't apply, and we were quite strong on those things, but we went into a position that on the assumption if the court decided for whatever reason that you had to pay on that. So we actually we asked them to get to speak to tax and financial consultants as well. So we got our clients to seek advice not just from the lawyers but also from the tax actuarial valuers to figure out that if they had to pay in terms of the amount, what would the amount be? Uh, would there be an interest component also? So we got them to do the math of what the liability could be. We also factored in, we took it one layer saying this is, X. We also went into the fact that assuming there is some penalty or additional interest, then we looked at historically what those numbers could be. We looked at the range. We said that factor that range in as well. And we said this is what could be a potential liability for you. Then we looked at, of course, the best case scenario. We were there because it was an absolute win. We were not required to pay. My client was not actually willing to look at a consideration where he didn't have to pay. He says, there is something that I need to give because it's a relationship. Um, uh, so therefore, we did this entire exercise. And Jonathan, this was actually not during the negotiation phase. This was pre-mediation. So once we got the notice, when the judge said, when the tribunal member said that matter referred to mediation, and we fixed the date for the mediation, all these conversations we had before we got onto the mediation table, because we were my clients from the beginning, even before even during legal notices, before things, my client had always been in position, let's try and settle. In fact, during the legal notice stage itself, my client has suggested mediation. uh, and, I- and and we
When you
believe that one of the reasons why it referred to mediation is because when we went to when we filed an application and at the hearings, we actually mentioned that our clients were willing for looking at mediation, and we had also said in the legal notices we had suggested mediation also.
I think it's very interesting. So you mentioned that all this happened, the strategizing happened in the pre-mediation stage, because when we speak to a lot of lawyers from law firms, and I who I personally know, they say, hey, we basically mediate to buy time. When I speak to my advocate friends, they say, what, there is no role to play, and they just in a mediation session. What you said is very important, where you actually sat with the client on the laws. The first thing that you did was you sat with them on the laws. You went into what is the worst case scenario and the what ifs. You got
Right.
experts involved to look into what are the possible penalties, taxations, and other other monetary sums that they might have to pay. And then you looked into the best case scenario before going in, and which I feel is very, very important. I am yet to come across a situation where the council has actually prepared and strategized with their clients. So that is very, very um, interesting.
But I also
And
have to say the client was also very, it's not just that the lawyers, see, the client was willing to participate in the process. I think that's very important. We've had situations where it's not, yeah, sorry, Jeff.
Hector, I'm interested as a mediator. I'm interested in. Did I hear right that you told the mediator what you were prepared to settle at?
We
So
gave
that's
them that at a certain point, saying that we didn't give them an exact number, but we said we were willing to settle and we had a number in mind. When he said, what are you looking for? We didn't give him an exact ballpark number because that would have just changed. So we did. So we had conversations with the mediator. So the mediator was aware that we were willing to settle. We had informed the mediator that we were looking at a win and in the NCLT, and we were very sure about it. We also told the mediator that we had worked out certain maths, etc. And we were not willing to offer what he was asking for. But we did start with what our initial offer would be. So we had, in fact, when we were working with a client, we said we will start with this, and then we left room open for negotiation, and we also had our, fall away point that if the demand is going to be more than X and they'll stick to that, we walk away from the table, because then it doesn't make sense. Then we'll fight it out. Because so while we had done this entire, Batna Vatna and bringing their things, from a commercial perspective, our client was like, I don't want to look at being settling much higher than this, because it also sets a precedent within the company. So he was very clear that I will, if a tribunal orders me to pay more, I'll be willing to pay more. But from a reputational perspective, I don't want to be seen that I can settle at any amount and whatever is demanded. So he balanced both those things and saying, while if the tribunal orders, I'm willing to go, and I understand what it is, but at the same time, from a reputational, from a company perspective, I don't want to also set a negative precedent.
Okay.
It's interesting. It's often easier for parties to go to trial, get told what they must give or receive, than settle. It's almost easier, especially for a corporate with middle management who doesn't want to be criticized for any outcome of the mediation. It's often easier that they do go and get a judge to tell them. And I think that's one of the barriers that mediators and mediation advocates have to deal with. Look, it's easier if the judge tells us, even if it's more.
True, but that's what I said. So, but for me, luckily, there was a client who was willing to participate in the process, and and understand where we were coming from, and go with the flow. So we actually spent a couple of days going back and forth in terms of value, and he was very clear, because the boundaries were for him. He says, number we'll get at, we'll figure it out, but he says, I'm also looking at precedent with respect to other employees, because those for him were the larger interests. And that, if it was not such a positional mediation, it would have been wonderful to see that play out. Unfortunately, it didn't. Actually, I'll come to the third case, and the second case we can probably look at it. So it was an IP dispute. There were lawyers on the table. There were lawyers who were, so while so again here, it was pre-litigation, it was legal notices. So we decided that we'll give an attempt to settle. Again, client was very supportive in the entire, when we were looking at Batna Vatna, we looked at worst case scenario, best case scenario. My client was a small fry. It was sued for it was a claim for infringement with a company which had deep pockets, very large. We had told the clients that, when we were doing the Batna Vatna, we were like, there is no way we can say that you have a very good case. You have some leg room coming in. So we were very keen to settle. We actually looked at lots of different strategies, including giving the other party, seeing what the other party would want. So this is actually getting before we got onto negotiations. So in this case, the negotiation failed, and we went into litigation. But when we were doing the entire pre-litigation, pre-mediation or pre-discussion talks, we actually went into, okay, we are looking at safeguarding our interests. We want to look at continuing use of name. We also considered things like, if we had to go for a brand change, what would we look at? We were trying to, we were playing the devil's advocate at every stage. Saying that, I come saying that I have a registered trademark, I've been using it for so many years, I have goodwill, I have brand value. At the same time, their brand value was of a particular region, but that region is dominant. My client might be a known player, but it was newer. It had goodwill, but it was in a smaller area or a location in India. So from a name recall perspective, if you used a particular name, majority of India would sort of recognize the person who had sued my client. But when we had discussions, we actually looked at discussions on how do I look at, if I want to look at a brand change and I have to agree to a brand change, what would the time cost we would look into? How do we do a PR exercise about the brand change so that, it doesn't look like I've agreed to something and I don't have the ability to either, to execute it properly, or it becomes a reputational issue for me. So we actually went into exercises like, if I have to do a brand change, how much time do I want? How would I want to visualize it? And these are discussions that would not come onto the negotiation table, but this is something that my client had to factor in to say that, is this something even worth me discussing? So some of these, so one is that. Second, we were like, if we want to talk about, if their brand is of value and we want to continue using, can we support them in terms of their brand? So can we look at some sort of a licensing arrangement? Can we look at, paying them certain amount of royalty? Can we look at money? So we actually went through, by playing devil's advocate, we looked at multiple options. Um, but when we went onto the negotiation table, uh, there was never any participation from the other council on the other side. For them, it was just my way or the highway. I just want you to stop using it. I don't want you to listen to anything else. I want it as of tomorrow. I want money. I want I want you to do this. And when we said that let's talk about it, because we feel that we can offer you value if we sort of partner with each other, because we can give you something that you don't have. We can help you fight some of your battles for IP infringement as well.
This you
But
said
they were like,
to the opposite council?
huh?
I said this is something that you said to directly to the opposite council or the party.
So yeah, so this is something that we said. That we said let's look at options available so that we can all work together. But in our mind we were like, we want to work together. So we actually came up with a proposal document. I said we came up with a proposal document which said option A, option B, option P, without getting to the finer details of what we would pay, what kind of engagement would be, but a very broad spectrum that's saying that we think there are multiple ways we can collaborate with each other without it being adversarial, without it being you versus me. But this was actually, and this was not something we gave on day one. This is something we went through like a couple of days of negotiation, and when we figured out they were still very privileged, so we said, maybe if you look at it visually it might help. So we actually gave them a proposal paper, but they were like, we don't want to listen to anything else. It's this or we go to court. So unfortunately that mediation failed. But in my mind, when I sit as a mediator, I think there was just so much on the table there that parties could have explored to come up with settlements that would work for both parties. And eventually, it would have probably led to my client changing the name and they getting what they want. But in the process, my client would have gained a lot more in terms of how they viewed themselves, in terms of a reputation, in terms of how they looked at the business as a whole, and the other side would have actually had somebody to sort of back for them in other jurisdictions, if there were other IP issues. But unfortunately, it didn't work.
Okay, interesting. And one final question just on this before we move on to Jeff. You did speak about a complete impasse, right? How did you, what did you do to break through that impasse? Were you able to communicate with the opposite council? Did you have, one-on-one interactions with them and all? How did you kind of try your best, to break through that?
So in this case, and this is where it was, the council, the mediator did try to help, in terms of breaking impasse. But I think the council and the parties came with the I am and so, and this is what I want. And I'm willing to settle for a little less than that, but I'm not going to move. So, breaking that impasse, so while we tried, we said, we tried to logic, we tried to reason with them, saying that, while you're looking at it, it's not a, the mediator also really tried to say that, to the, if you go to court, if you don't go, but they were saying, we don't want to listen to anything. We are very clear that this is what we want. So the impasse, the other party was, so it's like they actually walked to the mediation for the mediation to fail. And so breaking the impasse, so while the mediator tried, we tried with the mediator, we tried to say that, look, we understand what you're coming from, we understand that you're really trying to play a brand, and we'd like to support you in that endeavor, but we also have certain interests, and if you hear us out, but they're not really even willing to listen. So that's where when when you look at if it was a lawyer who was probably who understood mediation, while they would probably have their position interests, they would have engaged. Here, there was a complete lack of engagement.
Yeah, I think that's where Jeff's point comes back, that it is important to have well-trained mediation lawyers than just lawyers in the room. But the one very important thing that came out of both examples were preparation with the client is important. It is actually a very important part of the process. Again, mediation is seen as something by lawyers where they just need to enter the mediation center. but there is a lot of preparation that needs to go in behind the scenes. Jeff, I would love to know from you as a mediator. So Ekta shared her instances as a mediation lawyer. How about you? What is as a mediator? How is it been dealing with the mediation laws? Do we have a interesting case study here as well?
Yeah, I thought I'd just take a bit of license with the case study because I do want to preserve confidentiality. So I've sort of mashed up 2 or 3 mediations to make the points that I want to make. And I did want to focus on a mediator working with the lawyers before they get in the room. Now I realize, and I've been to the Delhi High Court Mediation Centre, I realize that sometimes that's not possible, but I'm talking about ad hoc, private, commercial mediations, and it's very much a process, not an event. So these days, with those counsel that have been trained, we don't necessarily talk about mediation day. It is a process, and from my perspective, I'm mediating from the very first time I pick up the phone and talk to the lawyers, and I'm trying to achieve a number of things over the course of the month or so before the mediation, and the main one is to build rapport with the lawyers. So a good mediator you will see them trying to build rapport, especially if you haven't worked with them before as counsel, and as a mediator you try and build that rapport, but morph it or evolve it into trust, because you're going to need trust down the track, down the process. So most mediators, from the very moment they have contact with counsel, will be trying to build the rapport and eventually work towards a really trusting bond between mediator and counsel. And if that happens, then you're going to have a constructive mediation. It may not settle, I'm not saying it will, but it certainly is the optimum setting for a resolution. And of course, working with counsel, as a mediator, you're a sponge, and the more counsel are prepared to tell you, the better you can do your job. So I always talk to lawyers about mediation intelligence, where, I really don't want to know about the case. I can read about the case. I want to know about the problem. I want to know about the dispute, and the dispute is often very different from the case, because the problem or the dispute has been put into legal language, and we now have our pleadings and everything else, which doesn't really tell me as a mediator very much. So I want to know as much as they're prepared to tell me. And funny lawyers often find this strange. I want to know a lot wider than the dispute. What's the dynamic? Why are these people in dispute when they were business partners or friends 3 years ago? What's changed? Why is it such a vitriolic problem? And all that helps me do my job. And if we look at the structure of how I go about that, I will often meet with all lawyers involved online a month or 2 before the mediation event, the 1 or 2 or 3 days we've put aside. And often I find that meeting really helpful, because I like to see how the lawyers interact. And trial lawyers will get this. It's a bit of a robing room vibe. So as lawyers robe up in the Delhi High Court, they will have some banter, and they'll talk about their last case together, et cetera, et cetera. I like to give the opportunity for the lawyers as a group to have that robing room moment, even in mediation. And we will deal with some fairly standard stuff in that all counsel meeting. Clients aren't usually there, although they're welcome. We'll talk about where the venue, who's attending, what expert reports are still outstanding, when the documents are going to be exchanged, and all importantly, from my point of view, I'll talk about the mediation statement, which is normally circulated between counsel and to the mediator, and that's a very important document. So we have that meeting, and then after that meeting, I'll arrange private meetings with counsel or the legal teams. And often clients come, although I find them actually more helpful if it's just the lawyers. They will often be much more candid with me as a mediator if it's just me and the legal team. Often that's a barrister, an instructing solicitor, or, the legal team within, a firm like Actors. So they can often be very candid. They'll say things like, look, Jeff, we wouldn't say this in public, but, we've got a difficult client. We've got a client management issue, and we're going to need your help on the 31st when we meet you for the first time. So you need to know about the client, this, and this. And that's, for a mediator, absolutely gold, because it helps me do my job. But again, that comes only when the lawyers trust the mediator. So it all comes back to the trust. I mean, Hector, I don't know whether you think that's over the top, but certainly in an ad hoc mediation, I'll spend as much time with the lawyers as they let me, essentially.
I was actually thinking of asking you a question when you brought this up. As a lawyer, you're not impacted by this at a very low level. And it's very, the parties, they, depending on the nature of dispute, it could get very personal. The outcome impacts them. But as a lawyer, you need the large picture. And having a conversation with the mediator, especially, if you understand issues, you can actually get through. You're looking at eventually a resolution for your client, and you're looking at a resolution that also works for your client. So I think that, if you are a lawyer having that conversation with a mediator, you can be far more free and open than a party can, or the party might be willing to. Jonathan, is this better now?
Yes, better.
Yes.
Okay.
There was a little
so I have no idea where this has come from, but
I think we get the gist of what you're saying, though, while you fix that. Yeah, Jeff, carry on.
Yeah, no, I get the point, and that's good to hear. I'll finish the structure just so people will understand what many mediators do. So we've had the robing room meeting, normally only half an hour or so, probably less. Then I meet privately with the legal teams, and that's, can often be very time consuming. They're often, a couple of hours long, and there may be 6 legal teams involved in the mediation. So, they're quite complicated meetings. And we discuss a range of things. I mean, one of my very basic questions I ask is why hasn't this settled? It's been a dispute for the last 3 years. Why hasn't it settled? And what barriers are we looking at come mediation day? And what's your plan to get over them? So I very much put the responsibility on counsel. I don't know. I've lived with this case for exactly a week. You've been living with it for 3 years. So you tell me why it hasn't settled, and how you think, what barriers you think we'll have when the parties do meet, and what are the strategies to get through those barriers, and what are the incentives? What's your guy, your client, what's their incentive to settle? Tell me frankly why they would want to settle, and don't tell me you've got a strong case and they don't care about whether they want to settle or not. Tell me why they want to settle, and that's often a really interesting response from lawyers who trust you. So I have a number of questions. Sometimes I won't try them because they'll probably not receive a helpful response. But most of the time, I'm after that mediation intel, and that's all on the private meeting with the lawyer. And then when we move to mediation day, I will again meet with the lawyer privately with the client and have 10, 15 minutes at the very start of the mediation to speak with the client and the lawyer. And the client will often have very legitimate and difficult questions for me as the mediator. They'll just want to see how I operate, see what sort of mediator I am. And I think that's a very important meeting. That usually happens on the morning of the mediation. So I start most mediations off with these private meetings.
So a clarificatory question is, so when you're saying that you meet privately with the lawyer and the mediator on the mediation day, is it, like before starting the session, you're spending 15 minutes with one party and 15 minutes with the other party before? Okay, perfect.
Yes. So we may not actually get together in our first joint session if we're going to have one, and I hope we are, for a first hour and a half of the day. But it often helps, especially the client. They will often tell me their story again, and I know their story, but they're going to tell it to me. And often they can, what I call, I don't know if this translates, but I often think they rub the sharp edges off their case, and so they've vented to me, which is fine. That's what I'm there for. And when they get in the room, there's somehow a slight softness in how they tell their story, and I think that's a useful kind of thing to do before the parties meet, because it's such an important time when they meet face to face.
Yeah, I think what you're saying is so interesting, actually, the both of you, because when we talk about mediation, so much focus is given to what's happening during the mediation stage, and we spend last 45 minutes just talking about what all can happen pre-mediation, right? And I think that is what sets the tone for mediation. It'll be a waste to not spend time pre-mediation prepping your client, as a lawyer, for a mediator to not be building a rapport with the opposite party. And I think Jeff has given us a wonderful structure that we can follow. That is in the pre-mediation stage, what he calls a robe meeting, where he meets both the lawyers of the parties, and they have a nice 30-minute ice-breaking session, so that there's trust building between them, post which he will have private meetings with the legal teams, the lawyers or the legal teams, which can run up to about a couple of hours. And then on mediation day, he's meeting privately with the lawyer and the mediator. So there's that much amount of work that goes in of the mediator with the lawyers. So that brings me to my next question.
Nishant, before you get into that, what Jeff actually mentioned, this things that why do you want to settle, and that actually stuck. It resonated. So because before I really got into mediation, if parties wanted to settle, we were like, okay, you want to settle? What do you want to settle on? Or what are you looking for? And we would ask questions that would just do your while you're trying to do a button off it, but it would be very superficial. It's only when I started understanding mediation, this, when you looked at your needs and your interests, you started asking questions like, why is it that you want to settle? What are you looking out of a settlement? So your questions were not very, while you're looking at settlement, otherwise, I would say the settlement discussions which I would have with my clients were very, very positional in nature. You're looking at this, okay, we will put it out in agreement. So now when I ask questions like, why, what are you looking for? We tend to go deeper. So when I look at even, while the results might still be, similar to what it is, but when I walk into the mediation, I feel more prepared because I understand where my client is coming from. And if I look at a proposal that sort of my client is not hearing, but I feel that it could have, impact what they were looking for, I have enough room to go back and say, you were talking to me about these concerns. How do you look at a suggestion or a proposal made by them? Because I think there might be an alignment here. What do you think? So I can have those conversations back, and my conversations with respect to how we listen to the other party also sort of increase much more, because the conversations we've had before, I think, set the tone for the conversations we have on the table. So simple
come in there
like
quickly?
why you settle becomes very important, and in law school we don't have conversations on why and what's and hows. We look at law very black and white and gray. So our training is that way, but mediation asks you to look at things in between as well.
Ekta, can I just come in here quickly, because I think you make a very strong point about conversing with the co-counsel, right? This is something that it's a very sensitive topic. conversing with the co-counsel, counterpart counsel in the pre-mediation stage. And this question kind of goes out to both of you. But I'm in the quick fire question range now because of time and the paucity of time. So I've introduced a new segment to this podcast now called the quick fire question, which means that we need to respond in like 30 to 60 seconds. All right. So to both of you, Jeff and Ekta, this conversation with co-counsel in the pre-mediation stage. A lot of mediators, by the way, are a little uncomfortable with this, that because they want to hold the process, they want to hold, once both sides have said yes, we are willing to mediate, we choose you as a mediator, we choose this institution as a mediator, then technically it's the mediator's process, right? And a lot of mediators are very, I wouldn't use the word insecure, but they want to be making sure that they are in control of the process, because if something goes wrong, it's their responsibility. So, how much control, Jeff, would you like to have in this engagement of pre-mediation counsel talk between themselves? Do you want to be involved in it? Do you want to be kept in the loop? Or are you okay with them just having a conversation by themselves?
It's funny, isn't it? Because when I'm looking for danger signs leading up to a mediation, what's standing out here? One of the things that puts a flag up for me is if counsel have not spoken. And I often say, how are you traveling with your opposite counsel? Oh, we haven't spoken. Well, we're heading to a $25 million dispute. We're going to be meeting for 2 days, and you're telling me you haven't spoken to your opposite number about the mediation. So that it's a danger sign for me, which I think shows you I have no ownership. I feel no ownership.
So you're okay with them? You're okay with them having a go by themselves without you in the room?
Of course.
Okay, Ekta, and that's something that you.
So that's something I try to do, but it doesn't always happen. But once in the room, I try to see if I can get, have conversations with the other counsel as well, especially the talks. As a mediator, also, I encourage counsel to go have a conversation and come back. If they're not talking there, I will give them specific tasks that I would like the counsel to sort of have a conversation on this, and let's see where it goes, and please come back. So
That's
I think conversation with counsel is important. Depending on counsel, depending on their awareness of the process, depending on the mediator, I think that there's several ways that can be done. But I think it's important for counsel to also have because eventually when we're looking at an impasse between clients, as counsel, we can't just raise our hands because we have a larger duty to our client. So we need to be paying that much more attention to see if we can actually help with the breaking of the impasse. So that conversation becomes important.
But breaking of the impasse, sometimes we are so focused on the role of the lawyer once the mediation is begun. I want to go back to another quick point that I observed when you were getting out those case studies there about, Ekta, you mentioned it. You all spoke to the mediator right in the start before the mediation could begin in the pre-mediation stage, and we told the mediator this is our threshold point. This is beyond which we cannot settle. We know what the range we are working with. You kind of put out a very clear intent to collaborate, a very clear intent to settle. Since you are doing this and you are a trained mediation counsel, you also are a mediator, so you understand the value of doing this in the start. But you might be sitting across an untrained and unskilled mediation counsel. Are you expecting similar behavior from their end? How do you use the mediator? How do you borrow the mediator in this time and say, see, I have worked hard with my client to work through the Vatna. I have worked hard with my client to show them what is the value getting this settled in mediation. I'm expecting the same from their side. So is this something you're expecting from a co-counsel in the pre-mediation stage itself, or is it too premature?
I think I don't expect anything from the co-counsel in terms of the
understanding. Why not?
No, because the way I look at it is that not everyone, we don't have mediation taught in law schools. There's no sense to this. So so when I get onto a mediation table, I assume that the other counsel, and I'm prepared for the other counsel not being trained in mediation or not understanding the process of mediation. So I go with the thing that I expect the worst, but I'm prepared for the best. So if they are, then it makes my life easier. But if they're not, then I'm prepared enough to see if I can use the mediator. So for me, one is the kind of questions I ask on the table then. So if it's a counsel who understands mediation, then our conversations flow very naturally. It's not about saying that what to look at it. But if it is not, then can say so I could ask things like while thank you for setting out so and so, and this is what we understand from your pleadings as well. But I would like to understand in terms of why your client is looking this. So I start asking open-ended questions to them, saying that I would like to understand. Could you explain a little more to me? And even if then they're stonewalling, then I will take it to the mediator and saying, this is very important for my client to understand why they're looking at something like this.
Yeah, but actually, I want to loop back into the pre-mediation stage, because what you're saying is very, very interesting. But I want to see how we can bring Jeff in as a mediator here. So you have worked hard on your client. You've got the partner understood. Yeah.
So I go back to the mediator, and that's it. When I get into the room of the mediator, in mediation, this is in mediation, I will go back to the mediator and say,
I'm saying in pre-mediation, can we work this out in pre-mediation, or is it premature to start talking about now?
I haven't done it. It's a good idea, but I haven't thought about it. But I think in pre-mediation also probably we could, saying that while we can set ground rules, saying that I'd like to understand if they're coming up with a position, I would also like to understand where they're coming from. I'd like to have conversations which are deeper, and make sure that in some of these pre-mediation discussions the other side counsel is also present, so it's not just me and things, saying that we are, while we all have our pleadings, if you could focus more on other interests, etc., then that would be more helpful to process. So then work with Jeff to set those ground rules as well. So work with a mediator.
Jonathan, often because a lot of lawyers know the process that I'm about to embark on, they will say to me things like, could you please tell them that we don't understand X or Y? We would really help us if they told you or told us, about X or Y. So often I'm getting messages from opposite counsel, could you please find out for us X and Y? So they use the mediator if they're not wanting to do it themselves. And that's, again, very useful for everybody.
And how do you, so once again to you, Jeff, because we do this training to train mediation lawyers. We have a couple of cohorts already. What would you say are the top skills for lawyers who are unable to ask their clients of these difficult questions right in the pre-mediation stage? Because see, sometimes we are going into mediation completely unprepped. And as I said, there might be a really skilled counsel on one side who's worked hard, and there is a counsel who's either not, interested and not really intentional about settling, or is intentional but has not prepped at all. So you as a mediator have a bit of a responsibility in that, so that is an effective mediation process. So are you the one then helping them ask the tough questions of their clients?
Yeah, if I need to. And mediator questions are often different from lawyer-client questions, but if I get the sense that they really haven't applied their mind to any of the things they will need to know as they walk into the mediation room, absolutely, I will do that. And so these processes aren't stuck in concrete. If that's the case, I'll say, Hector, I think actually, rather than just you and I talking before the mediation online, I'd like to set up a session with your client, because I do want to understand more about how they see X or Y, or what their response is. So I think if I get that sense, I'll absolutely ask if I can have some time with their client. Sometimes that's possible, sometimes it's not.
And Jonathan, if a question like this comes from Jeff, I can go back and prepare my client to give Jeff the information that Jeff really needs. Yeah. So what happens is then I become someone who can help fuel the process. Because if my client walked in without me working with my client, because I'll understand what information Jeff is looking for. And if I send my client in unprepared, the chances are that my client could stonewall. My client will not understand why Jeff wants it. There could be an issue of trust, especially if it is sensitive information. Or if my client has reservations on sensitive information, then work with my client to see if we can give away information that we need to give away while holding back on something which is highly sensitive. And then when the client is meeting with Jeff, also give Jeff a head start into saying that my client will share some information, but something is highly sensitive. They may be willing to share it at a later stage. So even Jeff knows that this information can come, but at what stage it can come.
And
And
that's
in matters like IP, etc., sometimes you have information which is highly sensitive that they don't want to put on the table with anybody.
yeah, absolutely. And see, this is where we are really, we're trying to stress on that point, bang on this very important aspect about the role of a lawyer is so crucial in that pre-mediation stage, because it's that space where you're searching for intent, both from the other counsel and also from your side. You're displaying intent to settle, to collaborate, but you're also trying to search for that from the other side. There's a lot of work that goes into asking those tough questions, both from your client and also from the other side's client. And and you spoke a lot about all the technical bits of it, Ekta, in the start, about how you went about asking those tough questions about what would happen if it didn't settle here, the cost of taking this down the adversarial route. But there are also interpersonal questions. There are also questions relating to say their mental state of mind, their emotional state of mind, whether they are willing to sit across the other person. This interpersonal communication skills, which there are some people who have not conversed with each other in a business dispute or in a personal dispute for years, right? And they're only conversing via their lawyers. So, Jeff, how much are you looking for in terms of that in the pre-mediation stage? Because see, lawyers are very happy to talk about legal positions and how strong their case is in court and all the technical parts of it. But do you find it difficult asking them those interpersonal questions about their clients, and so that you are ready in terms of designing a process and who you have in the room?
Well, they'll often tell me what sort of person the client is. They've got 2 children and, are separated and, as a CEO. They'll often tell me about their life, which is very helpful. But I suppose what I'm looking for is to see that the lawyer understands, and often this is a conversation I have with the client, that you don't need to prove anything in the mediation. Your job is to move this dispute towards settlement. How do you do that? Both lawyer and the client. How do you do that? Your job is to convince the other side that this is an acceptable basis to settle on, which is a very different process than we're right, you're wrong. And to be honest, most lawyers, and this is where the training is so important, most lawyers who haven't been trained will bring their court skills, their formidable court skills, into mediation and try and prove that we have a strong case, you have a weak one. Well, that may be part of it, but at the end of the day, it's to convince the other side that this is an acceptable basis for settlement. And I think that's a completely different mindset. And one, I remember being in practice and mediating, both as counsel and a mediator, and I found it very difficult to take off one hat and put on the other. So I don't underestimate how difficult that is for lawyers, busy lawyers who have got a court practice and are going to mediation. But training helps with that. And I would encourage everybody.
Quick fire question, 30 seconds each. What's the biggest mistake mediation counsel make in a mediation? 30 seconds only. So quick fire. What's the biggest one? I'm sure they make a lot. I'll start off with Ekta on this.
Trying to go only for a one-side win.
One-side win.
Looking at a one-side win, going in. So it's like going into court, saying that I'm going there and I want to get that win.
Okay, Jeff.
Yeah, leave something on the table. Quick fire response. Biggest mistake is not being likable. Be likable. And people want to work with you.
You're asking a lawyer to be likable.
Be likable. And that's why you speak to your co-counsel, speak to the mediator, be open, trust them. Sophisticated counsel operating at a high level. This is how disputes are resolved. Work out, do the legal rights trump the commercial incentives? Understand those commercial incentives, but be likable. Speak softly, but carry a big stick is my motto.
Awesome. Speaking of likable counsel, Ekta is one of them. But
Yeah,
Ekta,
I
are you
know.
always likable, especially when you have a client who doesn't want to go into mediation? So that's the next quick fire question to you. Uh, how do you pitch mediation to your client who is very, very stubborn and very, very clear that he or she wants to go down the adversarial road with complete destruction? You might actually lose your likability if you ask if you pitch mediation to them. Don't want you?
So I don't pitch mediation. I'm there as a counsel. So I give them an overall scope of what all options they have available. Mediation is
Right.
one of them. So I don't go and say you have to go for mediation. I will talk to them about, this is where your position is. These are the legal avenues open to you in terms of you seeking
Yeah.
recourse. And then I explain each of them. And then I say, what would you want? Um, and I also give them advantages, disadvantages of both, timelines, how we look at both. And saying, if you choose A, this is what we will do. If you choose B, this is what we will do. If you decide to go for litigation, straight away, this is what we'll do. If you're unsure, we can figure out, how do we get leverage in one and then move for the other. So I go through the entire thing. I don't say mediation. Because if
Right.
I say only mediation, I'm also, because I'm a counsel, I'm not serving the interest of my client. So I need to factor that. Paramount for me is the interest of my client.
Yeah.
And to serve that, I need to be aware of all forms of resolution available to my client.
Nice. Jeff,
And
have you ever been called in? Sorry, Ekta, I just want to get this across to Jeff quickly. Have you ever been called in by a counsel who said to you, Jeff, I'm completely convinced of the process here, but my client is just not getting it, and I am too scared to lose my likability, and to lose that rapport and trust that I have with them. And can you kind of convince them of the mediation process? Have you been ever called in? Would you get involved in this situation, and how do you do it? How do you pitch mediation?
Yeah, that has happened in the past. I must say, I find it difficult. I don't like to be selling mediation. That's not my job. I mean, but
Right.
clients have legitimate fears that they'll look weak if they, if they agree to mediation. I think that goes over time once mediation becomes embedded in the mainstream as it is in India. That concern goes. They worry about, I've got a strong case. Why should I mediate? They worry about, I don't want to show my cards before trial, all of which I can address. But I do it more as an information session as opposed to trying to sell the concept of mediation, because I don't think that's my role. I want to keep my neutrality, intact.
All clear then. I guess it's all about making them aware of what they're up for, what they can expect from the process, what they can expect from the mediator, what they can expect from the lawyer in the mediation setting. A lot of lawyers forget to explain to their clients that their role is going to change, that they're going to see them, that their clients are going to see them in a completely different avatar in the mediation setting. So don't panic. Don't be afraid that I'm not always on the front foot, arguing all the time, making a legal statement all the time. I'm in fact now the emotional anchor. I'm in the backseat. My role's different, and a lot of lawyers forget to do that. And if I had to take that question back to myself, what's the biggest mistake mediation counsels make is that they forget to address that point with their clients. They forget to tell them what they can expect from them in the mediation setting. It's slightly different.
And Jonathan, I when I'm training, I spend a lot of time on that issue, and I call it inoculation. So inoculate the client on that and many other aspects about the mediation, so they don't get frightened when they're in the mediation. So it's a really good point.
Nishant, I want to throw that last question back to you. What's the biggest mistake mediation counsel make in your experience?
I think my experience, the biggest mistake that they make is not preparing and strategizing before, coming into the session, because that is what depicts what they will do in the mediation. So I think for me, that's the biggest mistake.
That's a good point. In fact, we were discussing this at a conference yesterday. That even an opening statement by a mediation counsel needs to be rehearsed, because it can actually make or break the mediation if it's demonstrating an adversarial kind of attitude or an approach. It'll already get the other counsel's feathers up there and wings up there and ready to fight. So that's a strong point once again, Nishant, on strategizing and prepping for that mediation. This has been a fantastic conversation. We can go on and on with Jeff and Ekta. We know that. We've had these conversations at cafes and at restaurants over the last few years, and we can't wait to have more of those. But unfortunately, we've run out of time. This has been a fantastic conversation. For those of you who joined us live, thank you so much. For our friends in the UK and US who are going to wake up and watch this, welcome to the Mission Mediation podcast once again. We've had a fantastic conversation with Ekta Bal and Jeff Sharp and Chandler Ria. This is going to be ongoing. They're going to be having more of these every fortnight. So please do join us. And see you soon. Thank you so much for joining us live. Thanks, Ekta. Thanks, Jeff.
Thank you.